Okay, thank you all for joining. My name is Diana Palayo. I'm co-director of the Cancer Legal Resource Center. Today I'll be presenting on cancer and your legal rights, 5 legal tips. As a general disclaimer, the information provided during today's presentation is general legal information. It is not legal advice nor a substitute for legal advice and does not establish an attorney-client relationship. But with that, let me give a brief introduction into my organization. So the Cancer Legal Resource Center is a program of Disability Rights Legal Center. We are based in Los Angeles, California, though we provide our services nationwide. We operate under the educational model, which is to say we do not provide legal advice or direct representation. Rather, our goal is to provide information and resources on cancer-related legal issues to anyone affected by cancer. Our services are confidential, and we have resources in English and Spanish, along with interpreting services for other languages. So one of the ways that we provide our services is through our free telephone assistance line. You can submit an intake online or leave us a message to have someone call you back and help you fill out an intake over the phone. And we also have many fact sheets and resources on our website for free download. I want to point out our main resource, which is the Patient Legal Handbook. The handbook provides a brief overview of some of the most common issues and questions that people living with cancer and their families have. As I mentioned, is available for free download on our website, and we also provide bulk physical copies. And lastly, we conduct presentations throughout the year. Okay, so what are our 5 legal tips? Here's a snapshot of the issues. We'll get to each separately in their own respective sections, but I wanted to introduce them off the bat before we get started. Okay, so tip number 1 is it's the patient's responsibility to understand their insurance coverage. We tend to look at our doctors and other healthcare providers to know everything that they need to know about our healthcare, including insurance coverage, and to help us make informed decisions about our care. But they're not necessarily the ones who are responsible in making sure that what they recommend is covered by the patient's insurance plan. That's why it's the patient's responsibility to understand their insurance coverage. Having an understanding of what is covered and what costs you may have to share can help avoid any unforeseen costs and to help manage finances. There are different ways in where you can find the sources of information about your policy. It could be a summary plan description. It could be an evidence of coverage booklet. Those are either typically sent to you in a hard copy or available online. It could be the contract, or if you get insurance through your employer, a human resource department can probably help you locate that plan. Next, once you know that you need to understand your policy, it's also important to understand some of these policy terms. Some of the important terms to understand are copay, co-insurance, deductible, pre-authorization. You might see these terms often, so I'll briefly introduce what each means. So copay is a fixed amount you pay for a healthcare service. You usually pay that when you get the service. A co-insurance is the percentage, your share of the cost of the service. So it could be 10% or another small percentage in addition to what your policy pays out. And then there's a deductible. This is usually a fixed amount that you have to pay each year before health insurance plans begins to pay. And then lastly is pre-authorization. And this is something that you usually have to get for some expensive procedures before you get it through your insurance company before you can actually get that service. Additionally, there are different types of plans that come up when you're looking at insurance. There's an HMO, a PPO, and EPO are some common terms. An HMO is essentially a little bit more limited in terms of doctors and choices because you have select doctors in hospitals. It could either be an association of doctors or it could be a standalone hospital, something like Kaiser. A PPO is a preferred provider organization. This tends to be less limited than an HMO. It gives you more options, especially if you're looking at specialists. And then EPO is another plan that has popped up a lot in the health marketplace exchange. You can use doctors and hospitals within the network, but generally there are no out-of-network benefits. They may not be the most economical choice if someone's not interested in the network or the restrictions that the policies apply. The other thing to understand about health insurance is that as of 2014, under the American Affordable Care Act, the ACA, qualifying insurance plans cannot deny coverage based on a pre-existing condition. They can also not consider the other items here on this slide, so health status, medical history, genetic information, gender. The things that they can consider are your age and where you live. So in that same understanding your policy, it's also important to understand the types of private coverage. So the two main things I have here are private coverage. So first, COBRA and even state COBRA are options to continue employer-sponsored health insurance if you've left your job. COBRA is a federal law, and the requirements are if the employer has 20 employees or more. Then state law here in California has an option for smaller employers that aren't covered under the federal law. And essentially, this is you continue your coverage that you had through your employer, but you are now responsible for the full premium and sometimes a little bit higher than the full premium, especially if you're looking at mini COBRA. There's some options to continue coverage for a few months, for a certain period of time, depending on what you elect. However, if these premiums are expensive, or that plan that that someone had under their employer is not one that they want to keep, there are options to go through the health exchange. And in California, that's called Covered California. And there's a special enrollment period for qualifying events. Losing a job can be a qualifying event. So with that, let's look at Covered California. So Covered California is, again, a marketplace, and you can shop for plans in different tiers, and they're classified by metal color. So bronze is the lowest coverage, platinum is the highest coverage. A couple of things to consider about these plans are the bronze and silver plans, while they have lower monthly premiums, they may have higher out-of-pocket costs for care and higher deductibles. At the other end of the spectrum, gold and platinum have higher monthly premiums, but they may have lower out-of-pocket costs for care and lower deductibles. Additionally, when you're looking at plans on Covered California, there might be tax credits to lower the premium costs if your income falls within this range of 100 to 400% of the federal poverty line. And I'll have a chart in a couple slides to show you what those incomes look like in 2020. Annual open enrollment tends to be in the fall and goes through the end of January. These dates were from last year, and it might also be somewhere in the fall that open enrollment would begin. And there's also a special enrollment period going on right now due to the COVID-19 pandemic. It's until the end of this month, July 31st, 2020. In addition to private coverage, there are also public programs. So briefly, there's Medi-Cal. It's California's Medicaid program. It's for individuals with limited income and limited resources, others who fit this category of aged, blind, and disabled. And also under Medi-Cal expansion, California allows for individuals with 138% of the federal poverty line income to potentially be eligible. And then there's Medicare, which is typically for individuals who are 65 years and over or have been on SSDI for 24 months. Okay, so understanding healthcare and understanding and typical plan and policies are kind of like a puzzle. So when you put it together, one way of thinking about which source of healthcare coverage might be an option is to look at income. So if somebody has less than 138% of the federal poverty line, they might want to look at Medi-Cal. If they're between 138 and 400, they might want to look at the exchange for possible tax credits. And if they're over, if their income is over 400%, then they can still apply on the exchange or off the exchange with an individual broker. And this table gives you a scope of what that range is for an individual and a family of four. And of course, going to covercalifornia.com can help you learn a little bit more about your eligibility and other plan offerings within the marketplace. Right. So the second tip is to not take no for an answer. And when we say this, we mean learn about appeals. So we're going to talk about health insurance appeals and Social Security disability application appeals. So typically in health insurance appeals, you are able to appeal denials of coverage or insufficient coverage. It's always a good idea to keep the denial letter. The letter should also denote any particular appeal dates and deadlines. When trying to structure an appeal, it can be helpful to involve your medical team, especially if there's an issue of not understanding why the service was necessary. There are two types of appeals. There's an internal appeal with your insurance company, and there's also an external appeal if the internal appeal is unsuccessful. And there's also different procedures for Medicaid and Medicare. When it comes to Social Security benefits, this is another area of appeals. So generally speaking, to qualify for SSA benefits, you must be unable to work due to a severe medical condition that is expected to last a year or result in death. So a couple of things that can be helpful when applying for SSA is to check the Blue Book. The Blue Book lists conditions and ways of how to help with an application. You can discuss, applying for SSA benefits with the healthcare provider. If there are multiple conditions that are affecting someone's ability to work, it can also be helpful to include multiple conditions. There is this program that's known as a compassionate allowance list. So essentially, they're lists that SSA recognizes as meeting the definition of disability, and it allows for a quicker review of an application. It's not a guarantee of approval, but it does allow for a quicker review of an application. And then, of course, if the benefits are denied, an appeal might be something that is helpful. And the reason why we say or we focus on appeals is because less than half of SSA applications are approved, and most of appeal denials tend to be reversed. Reapplying instead of appealing could result in a loss of retroactive benefits or back pay. That is something that happens when you apply for SSA. It can take a bit of a while. So there's this period of back pay. And then if someone is interested in contracting with an attorney to help with an appeal, it's important to know that there's a cap of how much an attorney can charge for the services. For people with lower income, legal aids may be able to assist with SSA applications or appeals. Okay, great. So then this next tip is about the workplace. So we're gonna have two tips on the workplace. So the first one is about accommodations and requesting them before your work performance is affected. So there are federal laws, and there's a federal law and there are state laws that provide protections for individuals with disabilities. This can include cancer conditions. So we're going to start with the first one. So the Americans with Disabilities Act is a federal law. It was signed in 1990, and it's a pretty comprehensive piece of civil rights legislation. It prohibits discrimination and guarantees that people with disabilities have the same opportunities as everyone else to participate in mainstream American life. It applies to different sectors of American life, but today we're going to focus on employment. So in order to understand the ADA and how reasonable accommodations work, let's start with understanding its definitions and its protections. So it applies to state and local governments, employers, and if it's a private employer, it applies if they have 15 employees or more. In order to be an employee who's covered, potentially be an employee who's covered by the ADA, they must have a disability. And a disability is defined quickly as a physical or mental impairment that substantially limits a major life activity, and the employee must be qualified. And qualified means, one, qualified for the actual job, meaning that you can perform, or the employee can perform, the essential functions of a job with or without accommodations. So what exactly is an accommodation? So a reasonable accommodation is a change or adjustment in the work environment that enables an individual with a disability to enjoy equal benefit and employment opportunity. So another way to think about it is a modification. So it could be a modification to the physical environment, say a chair, if it's a standing type position, a change in schedule. Just really think of that in the broad sense. The other thing is that a reasonable accommodation is only available to those with a current impairment or a history of impairment. The ADA also offers protections for individuals who are regarded as having a disability or associated with someone with a disability, but they would not have the reasonable accommodation as an option. It's only those for current impairments or history impairment, and that could also include, say, someone who had a cancer condition, is now in remission. That's the way to think about it. Another thing is that it applies to all terms and conditions of employment, including benefits. So the reason why we say it's important to ask for a reasonable accommodation before work performance is affected is that while the ADA protects for discrimination against someone with a disability, if an employer doesn't know that this person has a disability or they have not requested a reasonable accommodation, then it makes it difficult. It might allow for a situation where work performance is a reason for, say, a termination or discipline, whereas the work performance could have been mitigated or avoided if a reasonable accommodation was given to the employee. And usually that could be something also like, say, fatigue or something else that's interfering. Usually if someone's having cancer treatment, that's another way of thinking about it in that scope. And I did mention that there are state protections, and I want to flag the one that we have here in California. It's the Fair Employment and Housing Act. And it is broader in terms of protections than the ADA. It has a broader definition of disability, and it specifically lists cancer. It applies to employers with at least 5 employees. And unlike the ADA, which the definition of disability required substantial limitation on a major life activity, here in California, it's only limitation. So I did want to flag that since I'm in California, and it might be, it's a broader protection. So if someone suspects discrimination, what are some options? Well, there are typically employment law or labor law attorneys who can discuss whether it makes sense to take some of these next options. So either file a complaint with the state agency, like previously that would be DFEH, file it with the federal agency. The one in charge of enforcing the ADA is the Equal Employment Opportunity Commission, or whether filing a lawsuit makes sense. Right. So the next step is also, again, employment-based, but this has more to do with taking time off and keeping your job while you're taking time off. So we'll start with the Family Medical Leave Act, or FMLA. So the FMLA, it offers 12 weeks of unpaid job and health benefit protected leave per year. So there are a couple of really important components here. First, it's unpaid. Second, it offers job protection. So a person who takes FMLA leave, when they return from their leave, has the benefit of being put back into their position or a similar position. And the third part about this is the health benefit protection. So while a person's on the leave, if they get insurance through their employer, their insurance continues throughout that period. Next is, who can you take this leave for? So an employee can take it to take care of themselves or to take care of a covered family member. And the law lists who's covered, but some of the initial ones are spouse, child, parent. Those are some of the categories to think about. Right. So similar to the ADA, there's distinctions between covered employer and covered employee. So for covered employer, it's all public employers, local, state, federal, and some large private employers. So that means that they have 50 employees or more in a 75-mile radius. Next, to be a covered employee, the employee must have worked for 12 months with the employer and 1,250 hours in that last year. Some quick math means about averaging 24 hours a week to meet that 1,250 hour criteria. So next, as I mentioned at the beginning, this is unpaid, but the unpaid leave, but there are ways of substituting paid leave while on FMLA. So it is possible for the employee to choose, or the employer to require that the employee use vacation or sick leave while they're on FMLA leave, essentially also getting pay during the time of the leave. This doesn't extend The FMLA leave, it just means that those days that you have sick time or vacation time, or someone has sick time or vacation time, they will be paid out of that leave amount. But sometimes, 12 weeks is not sufficient for individuals with cancer. You can take the FMLA leave intermittently, which is in little chunks of hours, and if possible, but still 12 weeks may not be enough. Or, as I mentioned earlier, the covered employer and covered employee requirements might make it so that someone's not qualified for FMLA. Either they work for a small employer or they haven't worked for the employer long enough. There's still some options. The first option is to check the employer policy. Some employers offer very generous policies, or even may offer an extra month or so. That's a good place to look. The second tip is, or the second part of the story is the possibility of requesting additional time off as an accommodation under the ADA or state law. So just as a note, while you can request additional time off once, FMLA leave is exhausted, employers do not have to hold the position indefinitely. Part of the analysis of reasonable accommodation is an undue hardship to the employer, and that's something that has to happen each time. So it's just something to note that it might be an option, but how much time you get will depend on, it'll be a case-by-case type situation. All right, so now we are at our last tip. And essentially, no matter anyone's health, documenting end-of-life wishes is important to do before it's necessary. So this next section, I'm going to talk about advanced planning, also sometimes known a little bit under estate planning. All right, so a couple ways to conceptualize this is planning for your property and planning for your healthcare. I'm going to go over a few advanced planning tools and how they might help in each of these instances and what they mean. So first, we're going to start with planning for your property. And one of the most common advanced planning tools that most folks know of is a will. So in California, there are 3 types of wills that are valid. There is a prepared will, which is one prepared by an attorney. There's a statutory will, which is essentially a form that you fill out that conforms to what's codified. And then there is a holographic will. And that one is essentially written in the person's handwriting completely, or for the most part. And those are some ways of preparing a will. A will is essentially where someone gets to lay out where you want your property to go to. And there are some formalities for how to prepare a will in each of these instances. Another tool that's useful, another planning tool that's useful for advanced planning are trusts. And this can be more useful for complex estates, but essentially a trust is an agreement created by a grantor or settler. It has the ownership of assets transferred into a trust. The trustee manages the trust and distributes the assets for the benefit of beneficiaries. As I mentioned, these are common for large estates. A benefit is that you can avoid probate, which is the court process for when someone is passing away and they're trying to distribute assets accordingly. And there are also other things that are helpful about a trust is that it can be effective during the life. That's known as a living trust. And sometimes a trust can also be accompanied by a pour-over will, which helps put any remaining assets that were in the trust back into the trust. And talking to a qualified estate planning attorney can really help determine which one of these tools is most useful when thinking about planning for property. That said, I do also think it's important to know what happens when someone does not have an estate plan or does not have a will. So this is known as passing away or dying intestate. And generally, property is distributed according to state law. So generally, it can go to spouse and children, the next closest relative, or to the state if no relatives can be located. It's also really important to know that some property already has a beneficiary. Things that are common are life insurance, retirement, pension. Those things have already a beneficiary, so it's a good idea to keep that information updated. The last tool is a power of attorney for financial affairs. And this can be a really important tool if someone is incapacitated and is unable to make their own decisions. Essentially, the principal gives an agent an authority to make decisions on their behalf. There is, again, formalities to how to make it valid. There are some forms that are statutory and free at cost. And another benefit, or another a way of another thing that can be put in the power of attorney is when it becomes into effect. So it could be something that only comes into effect when someone's incapacitated, or it can become into effect as of the signing. And again, this is also another document that can be prepared by an estate planning attorney. Okay, and the last tool is just about healthcare. So there is what's known as advanced healthcare directive, and there are a few component parts to it, especially in California. So in there, you'll have essentially instructions for a person's wishes about their medical care and treatment if they're unable to make medical decisions. There can also be a power of attorney for healthcare, and it's essentially naming an agent, naming somebody who can make those decisions for you. And then there's also information for organ donation and identifying the primary physician. And then there's also this post-most. So it's a physician medical order for life-sustaining treatment. This is typically something that is a patient and a doctor talk about, and it's usually this pink form. Again, a way of planning ahead for anybody's wishes about life-sustaining treatment. All right, so just again, a quick recap of what the 5 tips were. It's the patient's responsibility to understand his or her insurance coverage. Appeals are possible. Requesting accommodations before work performance is affected. Again, there might be an option to take time off work and keep job protection, and documenting your end-of-life wishes before it's necessary, which is really important. So just going to put this up here. We do have our intake. If anybody had any questions about today's presentation or any other cancer-related issues, our intake is at crcintake.org. And again, just want to thank everybody for joining today's presentation.